Good morning and good afternoon, everybody. Welcome to our webinar about trade secrets in China. My name is Hans Fuchs. I'm the CEO of CHINABRAND IP Consulting. That's a German service firm focused on the protection of intellectual property and know-how in China and other Asian countries. With me are my colleagues Mareike Seselberg and Xiao Liao. They will give you an introduction about regarding the latest trends in China. We plan to speak around 45 minutes. So let's start about the current situation of trade secrets in China. Mareike, the stage is yours.
Thank you. So I will take over and we will jump directly into our topic today, trade secret protection in China. I will give a short overview over the current legal situation and the situation of litigation in China and on changes that have happened lately. So let's start with trade secrets and trade secret litigations. As you can see here, we have sampled some examples. The first one, Tesla versus Xpeng Xiaopeng, a Chinese automotive company. Same as Tesla, they are developing autonomous cars. And there's a recent case from 2019 in which Tesla sues Xiaopeng for using its technologies and stealing of theft of trade secret. So these are two very big companies fighting on trade secrets, same as the second example, Geely versus WM Motor, Weimar. And what the point we want to make here is that these trade secret theft cases are involving quite a high sums of money. Like you can see here, 2.1 billion RMB is requested by Geely as a compensation. So the damages of trade secrets theft are quite severe. And the third example is to show you that even if the most trade secret cases still are between very big companies, there are also smaller companies having trade secret litigation going on, like Hongli Machinery versus Shunde Lixin Precision Machinery and Xiong Chenggang, which are two companies that you've probably never heard of. This is just to show that trade secrets are becoming more important and that litigation in this area will also involve smaller or medium-sized companies and not only like the really huge market players. Also, trade secret cases are not a civil thing, at least not all of the time. There are also criminal cases. For example, the ZTE case on 5G technology, where two employees of ZTE at the same time while being employed by ZTE for 5G projects accepted a technology outsourcing project at a 5G research institute. And while working for this research institute, they delivered technical documents and received project funds of 2.35 million RMB. So when this was handled by the court established the fact that the technical documents used by the two employees actually were ZTE's trade secrets, and that these trade secrets had been used for the 5G project. This means the information that the two employees used was exactly the trade secret and not some other technical information that they got on a legal way. And the losses suffered by ZTE as a result amounted up to RMB 4.3 million, which is quite a lot. So the result of all of this was that the two defendants, Mr. Huang and Wang, both were sentenced to 3 years of imprisonment. So today we want to focus on civil trade secret cases, as this is what will probably interest you more. On the left-hand side, you can see a chart showing the development on case numbers in China from 2009 to 2019. And you can see that from 2014 to 2019, the numbers have doubled. The numbers you see here are right. You're probably wondering that it's so low. So in 2019, there were roughly about 405 civil trade secret theft cases in China. Why is this number so low? First thing, trade secret cases are still growing in importance, so there are not that many at the time. Often there are other more workable ways to solve problems like this. And up until 2019, it was quite difficult for plaintiffs to get all the evidence they need for trade secret theft cases. And also the special thing about trade secret is that it's quite different from traditional IP, which means that for information to be established as trade secret, you need to implement certain protection measures. And the more you protect your trade secret as trade secret, the less big gets the risk that you will actually have a litigation later on. So the more focus there is on trade secrets and the better you protect your trade secrets, the lower the risk that you will actually get into a litigation later on. So on the right hand side, we want now to see what the results of these civil litigations were. And you can see they are not quite that good, because the blue part, 37%, are the cases in which the court was able to establish a trade secret misappropriation, while the red cases, 63%, the court had to decide that there's actually no misappropriation of trade secrets involved in the case. So what were the reasons of the courts to decide this? You can see here a diagram on the reasons why courts decided that there was no infringement. We will start with the smaller parts, which is the blue part, 4%, were cases in which the courts said that the technical information that has been used by the defendants was basically not the same as the trade secret of the plaintiff. The green part, 2%, were cases in which the information had been obtained via a legal way. The violet part are other reasons, which, for example, include cases in which the court established the fact that the trade secret, which the whole lawsuit was about, was actually not owned by the plaintiff. And then the most important part, the 64% in red, are the cases where the court decided that the information was actually no trade secret. And in most of these cases, this is not an error by the court, but this is a mistake by the company, because it's mostly the actions of the company that decide if information actually becomes trade secret or not. Why this is so, we will explore further in the following slides. But before we explore this further, I want to talk shortly about the improvement of trade secret protection on the legal basis in China. So, as I mentioned before, in 2019, the anti-unfair competition law in China was amended, which means that the parts on trade secret theft were added some paragraphs. And the most important of these new regulations is that there is an ease of burden of proof for the plaintiff. The plaintiff, starting from 2019, has now only to bring prima facie evidence to show that actually there was a trade secret and that it was protected as a trade secret in its company, and that this trade secret has been illegally assessed and stolen somehow. And if the plaintiff is able to prove all of this, then the burden of proof will shift to the defendant, who has then to show that the way he obtained the information actually was legal, or maybe also that the information or technical information that he used is not the same as the trade secret protected by the plaintiff. Another important change in China, starting from 2021, when the new Chinese Civil Code will come into force, is that there will be punitive damages for intellectual property infringement, which also includes trade secrets infringement. And also the Supreme People's Court has issued some documents related to disputes on trade secret infringements. And last but not least, the Supreme People's Court has also established an IP tribunal, which is directly at the Supreme People's Court and is meant to improve the quality of IP litigation. So, as I said, when courts decide that there's actually no infringement of trade secrets and that there was no trade secret, it's mostly the fault of the company, of the plaintiff, which did not identify or protect the trade secret enough. So actually, as you can see here, it's quite easy on the first view to protect your trade secrets. The 4 steps are: first, identification, then valuation, classification, and protection. We'll start with identification, as this is the starting point for the whole trade secret protection. As you can see, if you yourself as a company don't know what your trade secrets are, it will be very hard for a court later on to decide that there actually has been a trade secret infringement. So what you have to do is to check all your confidential information that exists in your company and to decide which of this information actually has economic value and what needs to be protected as a trade secret, because only this protection actually makes it a trade secret from a legal perspective. So the first step that every company should take is to make a list of all of this information to be able to themselves define what their trade secrets are. If this is done, it will also be easier for the courts in China to decide that there actually is a trade secret which can be infringed. So the court, what will the court do after they know what the content of the trade secret is? They will check if it's not public, if it has economic value, and if appropriate protective measures have been implemented by the plaintiff. So the first 2, not public and economic value, actually is not that demanding for the plaintiff. If there has been good documentation, it should be easy to prove that the information was not public available to everybody. And the same goes for economic value. If you have followed the steps like identification, classification, evaluation of the trade secret, it will be easy for you to give this trade secret specific value for your company. Here, something important is that it's actual or potential value. So the most difficult step will be to implement appropriate protective measures. This means there is no one-size-fits-all solution for all your trade secrets. What is important here is that your measures have to be adapted to the specific trade secret. You will have to make analysis, and after classification of the trade secrets, see what protection measures are appropriate for each single trade secret. For the protective measures, I want to once again talk about the case that I mentioned on the first slide, the Hongli versus Lixin case. Here, the case was that Hongli held that Lixin had stolen their trade secrets, and Hongli was able to prove that they actually limited the scope of the trade secrets and informed only the ones that must know the contents. They drafted 3 documents: the photocopying management regulations, management system of technical drawings, and information of the company, which regulate the scope of the company's technical information. They defined the content of the trade secret. Also, storage, borrowing, copying, and recovery of these documents was regulated. Then the second step of the protection measures was the security mark on all of these documents. So the trade secret was actually stamped as internal use. So there was no way that somebody of the employees or anybody else could pretend not to know that this information actually was only for internal use and for not to be disclosed to others. And actually the baseline of all trade secret protection is the signing of a confidentiality agreement with your employees. My colleague Zhao will talk about this a little bit more later on. So for valuation and classification, this comes hand in hand actually. So according to the value and the importance of the trade secrets, each company has to decide for each trade secret if they are high, middle, or low, if they are to be classified as high, middle, or low. And this will help you to be able to track your trade secrets and to have an overview on what trade secrets you have and which of them are most important for your company. So actually at this step, the latest, if you have made a list or used the software at the first step of identification, this is the step where you the latest should start to use a management software, or Excel sheet will also do probably. And if the classification is decided and you know the value of this trade secret to your company, it's the right time to decide on a protection level for each trade secret and to assign certain protection measures to each class of trade secrets, high, middle, and low. So in regard of protection, what needs to be considered when drafting protection measures and protection guidelines is what are the most common ways of leakage of trade secrets. And you can see it very clearly here that the biggest risks are your own employees, with 69% of all cases. And the second highest risk are business corporations and negotiations, amounting to 20%. There are other reasons, theft of third party and other situations, 8% altogether, and reverse engineering and independent discovery, 3% together. These two ways, the reverse engineering and independent discovery, are actually legal. So if somebody independently discovers the same information, that you protect as a trade secret, it's a legal way of obtaining this information. My last point also on protection is that you should always have in mind the cybersecurity. Even if hacking and industrial espionage is not the highest risk for your trade secrets, is still something that has to be considered, and something that can be prevented by an appropriate cybersecurity system. Also important is to train your employees how to use, for example, their laptop in other networks, or security risks of emailing and things like that. And with that, I would like to hand over to my colleague Zhao.
Thanks a lot. For the protection of the trade secret of the company, it should be noticed that there are two kinds of measures, namely precautions and the remedies. Here, I want to remind that the precautions are more effective than the remedies. And as my colleague just said, the main two reasons for the disclosure of trade secrets in the company are disclosing by the employees and disclosing by the business partners. Therefore, the precautions could also be divided into two aspects, namely inside the company and outside the company. To manage the trade secrets of the company inside the company better, so many Chinese companies have already developed the trade secrets management rules. And by the drafting of such management rules, they have used the national standard of the specification for administration of IP rights of the company. But here I want to say, this standard is very general and not detailed. So it's better for the company to draft their own trade secret management rules in the company. And this trade secret management rules should not only generally for all IP rights in the company, but specifically for the management of trade secrets. And there are also another two reasons for that. The first reason is that these management rules can be recognized as one evidence to prove that the company had already taken appropriate and specific protective measures to protect the trade secret of the company. And the second point is that in the trade secret lawsuit, the key point is that the company should provide so many evidence, but not one evidence. So with these management rules and the measures implemented by these trade secret management rules, the company can achieve this goal. Here, I would also like to remind the companies by drafting such management rules is necessary to define the scope of trade secrets of the company and also the specific measures and the responsible persons, also the penalty of the disclosure of trade secrets. After the management rules of the company is drafted, then the company should implement the measures according to the management rules, especially for the measures against the employees. Here, I would like to talk about more about measures against the core technical staff. If one core technical staff is hired by the company, then the company should realize that the core staff may be bring such risk. The first risk is that the technical staff may be used the trade secrets of the former employer, and the second risk is that new core technical staff may be violate the non-competition clause and NDA with his former employer, and all of that will lead to the infringement of intellectual property rights of the former employer. So, if the company wants to avoid such risk, it's necessary for the company to take the measures against the employee. For example, the background check before the recruitment of the new core staff, or the new core staff has to sign the commitment not to use other service inventions or to not use the trade secrets of the former employer. What is the most important is that the company have to sign the contract with employees about non-disclosure agreement and non-competition clause. This is the most point for the company. Here, I would like to further talk about the measures outside the company. In this situation, I would like to explain three different situations. The first situation, also the most important situation, is a business partner. When working with the business partners, the company has to always check carefully if the business partner is using the trade secrets of another company. If the acquired trade secret was obtained illegally, then the further disclosure or use of this trade secret will also be considered as infringement of the trade secret. So in this case, the company should always take care of that. And if the company has to provide the own trade secrets to the business partner, there are also some measures the companies has to take. For example, sign the confidentiality agreement with the business partner. And in this agreement, the company can require the partners to take responsible measures to protect the trade secret, or prohibiting the OEM from the manufacturing the same or similar products from another purpose to supply the licensor. And for the second case, the affiliate, and the third case, industrial espionage, there are two different measures. For the affiliate, the company can educate employees about the information transfer with affiliates and sign agreements for each transfer of the trade secret documents. And for the espionage, it's always necessary to sign the confidentiality agreement with the former employees in case the former employees disclose the trade secrets of the company. What I have talked about just now is all about how the company can take the preventive measures to avoid the trade secrets of the company being disclosed. But if the trade secrets of the company were already disclosed and the company is also in the civil proceeding, then the company has to take other measures to protect its trade secrets. For example, during the civil proceedings, the company can apply for non-public hearing or non-public cross-examination. At the same time, the company can require all the participants in the lawsuit to sign a confidential commitment. These measures are not intended to avoid the trade secrets will be protected like before. The aim of these measures are to prevent the trade secrets of the company being known to more and more people or companies and causing more damages. Another interesting point about the trade secret lawsuit is how the company can determine the amount of the compensation in the trade secret lawsuit. This question is also very practical in China. According to the Chinese laws and the judicial interpretations, the method of determining the amount of trade compensation in the patent infringement lawsuit could also be used in the trade secret lawsuit. Here, I would like to take the real case of Zhejiang Xinhe Chen as example. In this case, the court in the second instance has ruled the defendant has to pay the compensation amount of 35 million RMB. And also in this case, the court has ruled the factors of determining the compensation include but not limited to the amount of sales of the accused products, the profit of products, or the fact that the defendant has bad faith. And also in this case, the court has also taken the punitive damage as a factor to determine the compensation of the trade secret lawsuit. And further, my colleague will talk about the trade secret protection in practice.
Thank you very much, Xiao. Let me finally report about our experience in China. We have done a lot of cases, and currently we work in the sectors of chemical industry, new materials. So there's a lot of experience we can report. In general, the sector of trade secrets is strongly growing compared with patent infringement or patent nullification procedures. Strongly growing. The reasons are clear. It is much easier than a patent infringement. It's very easy to steal know-how. Know-how is normally not so strictly protected. But we have also a fierce innovation competition. The competition between particularly Western companies and Chinese companies is very, very aggressive. So more and more companies or their employees look to get some latest newest technological know-how. We have shorter technology cycles, for example, in artificial intelligence, self-driving cars, new materials, 5G, and so on. So this makes it impossible. It doesn't make sense to register patents in this sector because patents are relatively slow. They need a lot of time until they are granted. So the know-how protection is fast. If you have measures, you can protect your know-how immediately. You don't have to wait. And finally, we have a decoupling of economies as a result of the United States pressure and the recession in China. That means that more Chinese companies, also infringing companies, looking to Europeans. We are addressed, we are a new target or more important target for some Chinese company. This makes a trade secret a very hot topic. In our experience, the companies in China, the Western companies in China, do not have awareness. They are not aware of their trade secret and knowledge problems. There's no idea about this, and they do even not know their trade secrets. If you ask, what is your trade secret, A, B, C, D, and so on, they cannot answer. That's a problem, that they have no idea and no view over this. In practice, the theft by employees is much more common in China than by external hackers. When we read newspapers, there's mostly reported about hacking from China. This is not the case in China. The most trade secrets are stolen by employees during the work. Employees sell the stolen know-how or use it themselves for their own business. They make money, and often they work in networks. They have relatives. They do not act in one act. They steal the know-how continuously, step by step. That means that there is a permanent outflow of know-how, undermining the business of the Western company over the time. This is important. There's no big bang, no crash or so thing. It is a permanent loss of know-how over the time. The networks, I told you, are often relatives or family related. In many cases, one of the network employee of the network member remain in the company to constantly supply the network with new information. We had some cases with that patterns. Currently, attackers are targeting business secrets such as customer lists or supply data for calculations. So at the moment, we do not have a focus on technology know-how. It's more on the business side. The standard approach or tool for trade secret consulting or service is doing an audit. Here, critical is that you must bring the right people together. This is an example from the chemical industry. We have prepared the workshops. We created 3 groups. The group A is R&D, engineering material, the production, the hard fact people. They speak the same language and they have a similar background in know-how. Another group was customer relationship, marketing, sales. They have another language. They have other know-how related trade secrets and risks. And finally, the group number C was HR, legal, IP, facilities, security, and so. So we divided the whole people, the whole group of involved people in 3 groups. Many are a little bit shy. This is a problem to discuss trade secrets in a group. So we have additionally done one-on-one interviews in the afternoon and analyze documents. So you must be aware that this is a little bit sensitive sector. The main tool or basis of our work is a comprehensive protection database containing around 850 detailed questions. For example, have a look here. Are regular, irregular, or random checks carried out in accordance with the cybersecurity law? That's extremely specific, the question. We have a new cybersecurity law in China as well as the corporate social credit system, and this changed the situation. In front of these challenges, there is something to discuss about trade secrets. So it's a lot to do, but if we do the work, we do it right. The content of the database, you see here the list. We have an assessment scheme and the document security. This is the other chapters of the database. Human resources related questions. For example, you have 50 or 80 questions related to the human resources department, traveling security, legal measures, and so on and so on. You see, this is a lot of work to do, but you can select some chapters, and then the workload will be reduced. The results of this inventory, you can compile a trade secrets inventory or register. It's often the first case, the first time that a company has an overview as a result of this audit. We assess the trade secrets and their carrier, who owns the trade secret, who has access to a particular trade secret. We can create a worst case scenario, identify security vulnerabilities, analyze, evaluate the risks. We can define best practices and so on. You see, the result of this inventory is very fruitful. It's a lot of results that we get. We divided the measures in these 16 protection areas. This is our approach. In total, we can make a difference between around 300 measures, maybe 320 or 280. It depends on the definition of the measure. This is a particular case from one company. This is not generally valid here. You see, this company has a very high risk in the organization, in the document sector here, information system, leaving employees and devices. So it's clear this is a technology-oriented company. They do not have a risk in visitor precaution. There are no visitors in this company. No? This is case by case. We have to find what are the main risky areas and select, as a result of this analysis, select the right measures. Now, it's absolutely impossible to install and buy the equipment for 300 measures, so you have select some. And this is a table or a traditional method to analyze which is the best measure or which are the best measures. For example, look, this device is Cyber Attack Tracer. This is available on the market in China, for example, in the Western world, in Europe. You can analyze exactly what is the function, sustainability, how expensive is it, the compatibility with other devices, are we dependent on a supplier, and so on. You can evaluate, give points, weight the points, and get a total score. And so you find the best measures, and then you may combine maybe 6, 7, 8, or less than 10, 12 measures. It's also mainly a question of the expenses. But you must find the right measures. Which of these 300 possible measures are the best for your company? That's a process, how to secure a factoring. This was a factory, this was in Chanshu. You see, we started with workshops with the relevant people. To select the relevant people is very critical. Analyze the current case law in China. You should have a clear understanding of the legal basis, what happened regarding trade secret. Do the workshops. A lawyer should check the situation in the company, in the factory, with the planned measures. Very important, your documentation of the measures should court prove. That means you need a notarization. If you have an accident, a problem of theft of know-how later, and you go to court, and then the judge will ask you, can you prove that you have installed or implemented the measure before the accident? This is only possible if you have a notarized proof, a notarized evidence. Many of our clients try to roll out this. China is a very difficult place for trade secret protection. So the job is relatively hard. It's much easier in Europe or United States. So many companies, multinational companies or middle-sized companies with subsidiaries in different countries, try to roll out the protection system made in China, which we prepared for China, and then adapted this legally and then rolled out the system to other countries. So doing this, you can save a lot of money and a lot of time. We would like to recommend the world-leading trade secret portfolio management software, Hazel. It's an excellent software for managing all your trade secret, but only the metadata in this software tool. There is no real trade secret because it would be too risky regarding hacking. There's only a metadata, for example, the duration of a manufacturing process or the temperature of a mixture and so on, but not the exactly figure of this process or mixture. So this is a wonderful tool, particularly for bigger countries working in several companies working in several countries. What's the content? The trade secret portfolio management contains a classification methodology. You can categorize the trade secrets using a tagging feature. You can track the access of the whole ecosystem, who is involved, who has used which trade secret. You can review the whole procedures by using regular reviews, protection modules, and so on. There's also a historical audit trail of additions and changes. Who has changed the system in the last 2 years or so? That's quite interesting. Who was active in the trade secret system? That means there's no use of a cloud. It's very important in China related to the cybersecurity. You find some more information regularly on our blog, CHINABRAND.de. Currently, we have about 3, 4, 5 blog articles about the latest trends, latest developments in China. Our next webinar is an update about the cybersecurity in China. You know that China has a new cybersecurity law that makes the business for Western companies a little bit more difficult. We invite all the people to join this webinar. Thank you very much and see you again. Bye-bye.